Hi all, we are back again, and as you know that in the series of our lectures in which we are dealing with the concept of judgment writing, in the previous segment we talked about marshalling and appreciation of evidence. So starting from that point, I am going to give you an apt example of marshalling and appreciation, and once we are done with that example, that illustration, we will proceed further. So that example is something which is quite similar to any real case in the court of law, and the facts of that imaginary case goes like this, because in this illustration we are going to talk about a suit which was filed for the specific performance of the contract. And I am presuming that you have the basic idea as in what is a specific performance of a contract. And if you don't have that idea, please read specific performance of contract under Specific Relief Act. So you can imbibe the idea of specific performance from that act, but I am presuming that you have the basic knowledge about that, because I have taken the example from that part of our civil law. So in this example, in this illustration, what is happening? Two persons are there. One person is Mr. A and the other person is Mr. B. And Mr. B has borrowed 2 lakhs rupees from Mr. A. And there is an agreement between A and B that Mr. B, who has borrowed the money of 2 lakhs rupees, he has a piece of land. So the agreement between B and A is like this. The terms and conditions of that agreement are like this. They are writing in that agreement that Mr. B has borrowed 2 lakhs rupees from Mr. A, and they are going to have this agreement in such a way that after the completion of 2 years of time, if Mr. B fails to make the repayment of that money, they will execute a sale deed between them. Means primarily, according to Mr. B, who has borrowed the money, he is entering into that agreement just to make a security for the repayment of that money. But on the other hand, what this plaintiff who has given the money is thinking that he is giving that money as a part of the consideration of the sale. And parallel to this, they are executing another document in which they are writing the terms and conditions like this, that Mr. B has borrowed 2 lakhs rupees, and if after the lapse of 2 years he will not be able to make the repayment, the sale deed will be executed. But in the meantime, Mr. B will make the repayment in installments, and he will make the payment of 2,000 rupees per month as installment and 1,000 rupees as interest. So these are the all terms and conditions between those two parties. But after some time, a dispute arose between these two parties, and Mr. Plaintiff. So who is the plaintiff in this scenario? The person who has given the money, that person is the plaintiff, and he is bringing a suit for specific performance of the contract. Means he is willing to take that piece of land from the defendant, because the apparent price of the piece of land was fixed to be 3 lakhs rupees. So according to the plaintiff, out of 3 lakh consideration money of the sale, he has already given 2 lakhs rupees and 1 lakh is remaining. So he is thinking that, okay, I have to give 1 lakh rupees, and after giving that money, I will get the piece of land. So he is thinking in that line. But he has brought a suit for a specific performance of the contract. So what is happening in the court? Both the parties are making their pleadings, as we know in the civil case. So, who is the plaintiff? The person who has given the money. And who is the defendant? Mr. B, who has entered into that agreement with the plaintiff and he has borrowed the money. So, if you are the judge, what will be the issue or what are the issues in this case? How will you frame the issue? So, the first issue, I will write it for your convenience. I have given you the facts in brief. So, taking those facts in the background, now you have to think about the issues. Issues. So, number one issue will be whether there was a valid agreement between B and A. Whether there was, you can write it, whether there was a valid agreement between B and A. This is the first question. And was this agreement connected with or related with the sale of the land? Was that agreement related to the sale of the land? And did the defendant accept the 2 lakhs rupees as a part of the consideration of sale? Number 2, did the defendant, the spelling will be like this, accept the 2 lakhs rupees as the part of the consideration of the sale of the land? Because the plaintiff is in this trick that he is going to grab the land of the defendant. This is the idea, this is the background. So, the court is going to find out the answers to these issues. And what will be the next issue? Next issue will be, was the plaintiff ready and willing to make the payment? Was the plaintiff ready and willing to make the payment of 1 lakh rupees which was remaining? And now relief and cost. The last part will be relief and cost. So, these are the questions which will be answered by the court in this whole suit. And now the time has come that court will look into the evidence, because we are going to understand the idea of marshalling and appreciation with the help of one illustration. So, this is the factual scenario of the illustration. So, now we have to reach at the level of marshalling and evidence, marshalling of evidence and appreciation of evidence. So, the issues are framed by the court, but now we will look into the evidences produced by both the parties. Evidence. Means marshalling. Marshalling marshalling. Now the court will look into the evidences and court will make the sequence. So now the court is saying that the plaintiff has produced such and such evidence. So the first sentence will be about the evidence produced by the plaintiff. So what is the evidence? The plaintiff is saying that yes, there was the agreement between me and the defendant. So the court will write that according to the pleading of the plaintiff, he is not denying the execution of the agreement. So the agreement is a document. And what will be the next thing? The plaintiff, next sentence, the plaintiff has not produced any witness. Plaintiff ने कोई witness नहीं एग्जामिन करवाया है अपने behalf पे. So these two things are connected with the evidence of the plaintiff. So these two things will be produced in two sentences by the court. Means the court is going to make the sequence of the evidences produced by both the parties. So now these two things, that the plaintiff is saying that there was an agreement between me and the defendant, first sentence. Second sentence, the plaintiff has not examined any witness on his behalf. Two things. But what about the defendant? The court will write that the defendant has produced his WS, that is the written statement, and in the written statement he is pleading that the agreement of sale was executed as a security. The court is saying that defendant's document was produced, and in his WS he is pleading that the agreement of sale was not something which can be considered as a sale deed. Rather, that agreement was just a piece of security for the repayment of the money. Right? And after that, court is writing that both the parties were examined and cross-examined. Examination. So these are the things which will be written by the court. Means the court has made the right sequence of the evidences produced by both the parties. So in this paragraph, evidence will be marshaled. So this is the exact marshalling what the court has done. What evidence was produced by which party, the court has made the right and the logical sequence of all those evidences. Isn't it? And now the time has come to appreciate this evidence. Once the sequence is made by the court, now the court will appreciate it, the court will analyze it, the court will try to have the detailed analysis of the evidences produced by the parties. So now what is the court doing? Now I will make the heading appreciation. Appreciation means analysis of the evidences produced by the parties. So what is happening here? Now the court is saying that the whole paragraph will be written by the court. This paragraph will be comparatively lengthy, So the court is writing, the paragraph will be started from this point, like this. It will go in this direction. And what is the content? The court is saying that, look at the appreciation. The court is saying that the plaintiff did not show any bank account, account to prove that he was ready and willing to give 1 lakh rupees. Suppose the plaintiff is saying that I have already paid 2 lakhs rupees to the defendant and only 1 lakh rupees is remaining and I am willing to pay that amount, right? And once that amount will be paid by me, I should get the land from the defendant. But the court is saying that, okay, Mr. Plaintiff, you have not shown that you have the money in your bank account. So, without having any money in your bank account, how will you pay the amount of 1 lakh rupees? It is questionable. So, it is a part of the evidence which is court is analyzing and trying to have the appreciation of that. This is the first thing. And again the court is saying that, Mr. Plaintiff, did you serve any notice to the defendant that you are willing and you are ready to make the payment of 1 lakh rupees? Notice. Now the court is writing it again that the plaintiff did not serve any notice to the defendant that he was ready and willing to make the payment of 1 lakh rupees. So, you do not have money in your account and you have not served the notice on the defendant that, okay, I am ready to give you the remaining 1 lakh rupees, please accept it. You have not done that also. And what is the next? Because the plaintiff is having this crooked mind, he is planning to grab the land. But at the same time, there is an agreement, and on that agreement, there is the signature of the plaintiff. So, he is not denying his signature on the document. The plaintiff, the court is writing further, the plaintiff has not denied his signature on the document. Means there is no doubt about the existence of the document. And now the most important part comes. Look at the pleading of the plaintiff. What relief he is looking for? He is looking for the specific performance of the contract. But both the parties have made their respective pleadings, we know that. And according to the pleading of the defendant, what is he saying? He is saying that, no, my lord, I entered into that agreement when the plaintiff asked me to do that. And that agreement was meant as a security for the repayment of the money, and it was not something that I was going to execute the sale deed. So, it was just a matter of security. That agreement was just a matter of security. Means he is not willing to give his land. If the pleading of the defendant is that the agreement was only a matter of security, so the plaintiff must have countered this argument in his pleading, but he has not countered that. Means this statement of the defendant remains still unrebutted, not denied. Means the plaintiff has not countered this argument by the defendant. So, court will write it. The defendant's pleading that the agreement was just a security for the repayment of the money, remains unrebutted. Means the plaintiff has not countered this. And now one more thing is that when we go through the facts in detail, it was found that when the defendant tried to make the payment, the plaintiff had refused it, that no, I will not accept it. So, it was just a trick by the plaintiff that let me not accept this amount, and once time will lapse, I will get his land. And that is why he had refused to get the installment to receive the payment by the defendant. So, defendant had given this part in his pleading that I had made the attempt to make the repayment in installments to the plaintiff, but he had refused that. So, this refusal of the repayment by the plaintiff was something the plaintiff himself has not countered. Because if the defendant is saying that I had made the attempt to make the payment, but he refused to accept it, it means the plaintiff should have countered this also in his pleading, but he has not countered this pleading of the defendant. So, court will mention this also. The attempt by the defendant to make the payment was refused by the plaintiff, and the plaintiff has not countered that also. Means these two things. What two things? That the agreement, the document between the plaintiff and the defendant was only a matter of security, one thing, and the second thing, that his attempt to make the repayment was refused by the plaintiff himself. These two things were not countered by the plaintiff himself. So, the court is doubting the credentials of the plaintiff, and the court is saying that you have not rebutted, you have not countered these two pleadings given by the defendant. It means these two things are, these two facts. Which facts? Means the agreement was just a matter of security and you did not accept the repayment. These two facts were not countered by you, and hence these two facts remain admitted and proved. These two facts remain unrebutted by the plaintiff, and hence remain what? Remain admitted and proved. So, this is the end of appreciation in this scenario. Now, the appreciation by the court is over. So, if you become a judge, you will also marshal and appreciate the evidence in a particular case with the help of this illustration. So, I hope you understood the whole scenario, but what will be the next thing we will be doing? I just gave you one example of marshalling and appreciation of evidence. So there is an old saying that what are the features of a good teacher? How will you decide that this teacher is a good teacher or a bad teacher? There is no straitjacket formula, but still sometimes we say that good teachers explain things, and very good teachers, they demonstrate things. And there is the another category, that is the legends. The legends will inspire you to do your own things. So I am at this second stage in this lecture, in which I demonstrated the theoretical concept of marshalling and appreciation of evidence. And this demonstration was done with the help of this example, this illustration. So try to go through this illustration, and you will find that you are able to develop the real picture, as in what exactly is being done when the court is going to marshal and appreciate the evidences produced by the parties in a case. And once we are done with the theoretical as well as the practical aspect of marshalling and evidence, now we will proceed at this level. And what is that level? This black part is something which will come later. It was not a part of today's lecture, but I have written it just because I want to cover this part, judgment writing in civil cases at different stages. That will be the next part, which will be covered in the next video. So please stay with us. Thank you so much, and do watch our videos on our YouTube channel, and don't forget to like, subscribe and make your valuable comments. Thank you so much.